Hi, welcome to today's Federalist Society virtual event. Today is Monday, November 18th, and we are here to talk about the recent Third Circuit decision in Anderson v. TikTok, holding that social media companies' algorithms prioritizing and sorting of user-created content are not immune from liability under Section 230. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. I am delighted to have Professor Eugene Volokh with us to moderate today's discussion. Professor Volokh is the Thomas M. Seibel Senior Fellow at the Hoover Institution. For 30 years, he has been a professor at the University of California, Los Angeles School of Law, where he has taught and written on First Amendment law, copyright, criminal, tort, and firearms regulation policy. Please see his bio on our website for more, really not scratching the surface, but one interesting detail given our topic for today, Professor Volokh also worked for 12 years as a computer programmer, graduated from UCLA with a bachelor's in science in math, computer science, and has written many articles on computer software. As always, please note that all expressions of opinion offered today are those of the experts on today's program. We encourage our audience to submit questions for our panelists through the Q&A feature at the bottom of your screen. This is to those of us gathered here, I guess, a fun and exciting topic. There's a lot to cover, so we have blocked out a full 90 minutes for today's webinar. So we hope to get to a lot of your questions. So please do make use of that Q&A feature. Thanks very much for being with us today. Professor, the floor is yours.
Thank you. Thank you very much. It's a tremendously important subject that comes up, obviously, not just in this case, but in many throughout the country. There's a sense that there's been something of a change in attitudes among judges towards Section 230 immunity, and some invitation from the Supreme Court, or at least some justices of the Supreme Court, to change the attitude towards Section 230 immunity. Whether that's right or wrong is something that we're going to be hearing about today. So I will just to very quickly indicate who the participants are. Chris Marchese is the Litigation Center Director for NetChoice. James Burnham is the President of Vallecito Capital, LLC. Jennifer Huddleston is the Technology Policy Senior Fellow for the Cato Institute. And Ashley Keller is a partner in Keller Postman. So we're going to go in that order, where everybody's going to present their thoughts. Then there'll be a bit of a conversation among us, and then there'll be a conversation with you folks in the audience. So let's begin. Chris.
Well, first, I just want to thank the Federalist Society and the Freedom of Thought Project for putting on today's panel, and Eugene for moderating. I'm going to start by giving a little bit of an overview of Section 230, where it came from and what its core provisions are. So first, I think most people know Section 230 has been credited for creating the internet. It was passed by Congress in 1996. But what I think some folks don't recognize is that it grew out of a very intentional effort by Congress to respond to state court decisions that dealt with early online speech issues in the 90s. So just very quickly, there were two very prominent cases out of New York in the early 90s. One is dealing with CompuServe, and another is dealing with its main competitor at the time, Prodigy. So in the CompuServe case, CompuServe was sued for harmful content on its website. But because CompuServe didn't do any form of moderation or exercise editorial discretion, the court said there's no liability here, you're just a conduit. In the Prodigy case, however, the court said that because Prodigy wanted to create a family-friendly website, and it had things like content moderation standards and automatic screening and filtering technology, that it was liable for all of the user-generated posts on its website. Now, what's really interesting about the Prodigy case is that it was actually Stratton Oakmont, the brokerage firm that was made famous in Hollywood's Wolf of Wall Street. It's a great movie, but a very unfortunate real-life event. And what was interesting about the Prodigy case is that, Stratton Oakmont sued and won. And so Congress looked at this and said, wait a second, this is going to create a really perverse incentive where if we want family-friendly websites, if we want content moderation online, but we also want to have user-generated content at scale. We can't have this moderator's dilemma where if you moderate, you are responsible for 100% of the content on your website. And thus, Section 230 was born. It is the most commonsensical and successful tort reform in US history. It has a few core provisions. First, it outlines what Congress's policy goals are with passing the law. And those included trying to advance the development of the internet and user-generated content, as well as encouraging websites to perform moderation, to experiment with different types of technologies, including filtering technology and so forth. So the two main provisions that we'll probably be discussing today, as they come up in almost every Section 230 case, are known as C1 and C2. So C1 says that a website will not be treated as the speaker or publisher of information provided by another. In other words, they're not responsible for the content that users create. The second provision is C2, and that says, even if you perform moderation, even if you are somehow, curating or arranging or displaying the speech, you are still not responsible for the actual user-generated content itself. So these provisions are very commonsensical in the sense that it says liability will attach to the person who created the underlying content, not the website, or for that matter, other users who share or repost the underlying content that is harmful. And so the reason why I say it's the most successful tort reform in US history is because in the 90s, Congress looked at the internet and said, this is an immense technology. It is going to radically transform the economy and create untold opportunities for free speech. And in order for that to happen, we have to sort of prevent meritless litigation. And so Section 230 is a procedural tool. It says to the courts, when a website or another user is sued for someone else's content, the case should be dismissed very early on. There's no need to go through extensive discovery or motions practice or any of that. It's a procedural shortcut to ensure that websites of all sizes have the ability to exercise their First Amendment rights as they see fit. And that, in turn, enables users to post user-generated content. The reason why Section 230 is so important is because it recognizes that lawsuits are a means of suppressing speech, of chilling speech and so forth. Look at Stratton Oakmont, right? It sued and successfully won a defamation claim, even though it turned out that Stratton Oakmont very much was a fraudulent brokerage firm that caused a lot of harm to many people. And so the ability for users to use the internet to connect with each other, to create content, to share content, and to engage in content is enabled by this procedural shortcut in the courts. But of course, it's the First Amendment that protects the website's editorial functions, as well as the user's free speech rights and so forth. All Section 230 does is act as a procedural shortcut in reinforcing those First Amendment rights. I think I'll stop there before getting any nerdier.
Sounds good. Just a reminder from the appellate law world is judges always view that advocates that don't use up all of their time are showing real confidence in their case. So I appreciate that. Thank you very much. Moving along.
Okay, thanks a lot, Eugene. I appreciate it. Thanks for having me today. I will also try to use less than my allotted time. So I think it's a little easier to understand the issues if we make this a little less abstract. And the best way to do that is to talk about this actual specific case. And so I want to start with just the basic facts, which come from Judge Mady's opinion describing the complaint, which we take as true in this posture. 10-year-old Nyla Anderson died after attempting to recreate the blackout challenge she watched on TikTok. The blackout challenge, which was performed in videos widely circulated on TikTok, involved individuals, quote, choking themselves with belts, purse strings, or anything similar until passing out, end quote. The video, quote, encouraged viewers to record themselves doing the same and post their videos for other TikTok users to watch. Nyla, still in the first year of her adolescence, likely had no idea what she was doing or that following along with the images on her screen would kill her. But TikTok knew that Nyla would watch because the company's customized algorithm placed the videos on her For You page after it determined that the blackout challenge was, quote, tailored and, quote, likely to be of interest to Nyla. Those are pretty bad facts. Here's a few more. By the time Nyla viewed these videos, TikTok knew that 1, the deadly blackout challenge was spreading through its app. 2, its algorithm was specifically feeding the blackout challenge to children. And 3, several children had died while attempting the blackout challenge after viewing videos of the challenge on their For You pages. Now, what do we make of all of this? First, I want to establish an important distinction that Chris alluded to, and that's going to be at the heart of this. Platforms that speak for themselves, so CNN online, the NewYorkTimes.com, whatever, nobody disputes that those platforms are engaging in speech that triggers both the First Amendment and liability for things like defamation and the like. They're liable for what their own employees say. So as my friend explained, one of the major functions of Section 230 was to avoid holding platforms like Instagram or whatever liable for speech that they host that comes from third parties in the way that we would make the New York Times liable for speech that it provides through one of its reporters. And then it did the other thing where it said, even if platforms moderate content, that is, they remove pornography or violence or terrorism speech or whatever, that content moderation doesn't convert them back into publishers. And that's really what the case is about, in my opinion. How far does the content moderation exclusion from liability really extend? And it really keys to the fundamental difference between two things: a platform that hosts another person's speech and a platform that, in this case, pushes on its own, through its own algorithm, through its own conduct, particular third-party speech on particular users. In my mind, it's really the difference between the TikTok algorithm and a message board like Reddit or something, where Reddit is deleting pornographic, material and the like, but otherwise just letting users, basically post things and read it and talk to each other. I think, whereas here, you've got a platform pushing specific content like blackout challenges, anorexia videos, etc. And the way the platforms do this, the way the algorithms are designed, is they push things like anorexia videos or blackout challenges to the users that they think are going to be the most captivated by that content. They have a lot of data and they have a lot of analysis to figure out which things are likeliest to keep, in this case, young women glued to the platform as much as possible. And they organize the content, push the content, and design the content or design the presentation of the content, rather, to maximize the user's captivity, that is, because that's how they make money, is eyes on the screen. Okay, so Section 230 offers two ways out of liability, and I think it's very important to actually, read the text of the statute when we try to figure out, whether or not TikTok is liable for the death of this young girl. The first is C1, which we talked about. I'm just going to read it really quickly. C1 says, quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider," that is, a third party. Very simple. We just talked about this. The platform is not a publisher of all the third-party speech on the platform, the way the New York Times is a publisher of all the articles you read in the New York Times. So at the beginning, you can't just go through TikTok or Twitter or whatever, X or whatever, and say, this is defamatory, you TikTok or X is liable. They can't be held liable for the speech of third-party providers that they host. Pretty easy. Nobody's disputing that. The other way out of liability is no provider or user of an interactive computer service, this is C2, shall be held liable on account of, quote, any action voluntarily taken in good faith to restrict access to or availability of material, end quote. That is content moderation, the same thing we just talked about. So if X or Instagram goes through and it takes down pornography, whatever, terrorism videos, whatever, the fact that it's moderating the content available on the platform doesn't turn it back into the New York Times. Okay, but that's it. That's all the statute says in terms of what gets them out of liability. They're not a publisher. They don't become a publisher if they selectively remove material that other people have posted. I have a lot of trouble understanding how anyone thinks that limitation on liability protects what happened here. In this case, according to the complaint, TikTok designed an algorithm to push videos about choking yourself until you pass out to 10-year-old girls. Okay, that's TikTok's conduct that we're talking about. It goes far beyond actions taken to restrict access. It is a platform that is itself, through its own technology, promoting material, and then a plaintiff that wants to hold the platform liable for that promotion, the promotion of these choke videos, not for the videos themselves, but for what the platform did in, again, according to the complaint, bombarding this little girl with these videos over and over again. And then the last thing I'll say, and then I'll stop. One way to think about it, I don't use TikTok, and maybe in February, none of us will be able to use TikTok. But one platform I do use a lot is X. And to me, it's sort of the difference between if you follow people on X, you see what they say. And that's really just like a linear, basically a timeline of all the things that the people you follow said. But you can also go to the For You side of the feed, and that's where X is promoting its own stuff to you that it thinks you're going to be interested in. I think what the algorithm is doing when it sort of decides what you should see is something that is different from and outside of the Section 230 liability limitation provisions, and is something where if the algorithm itself, commits a tort or a harm, the platform can be held liable. Thank you.
And thank you. Excellent presentation. I think we're turning to Jennifer now.
Thank you, and thank you to my fellow panelists for such a lively and engaging conversation already, as well as to the Federalist Society for hosting this event on what I think is a very timely and interesting topic that perhaps hasn't gotten as much attention as the cases like the NetChoice cases, and before them at the Supreme Court term, the Google v. Gonzalez and Twitter v. Tamna cases, all of which are actually relevant to this conversation as well. So for my portion of this introductory conversation, I want to talk a little bit more about that context in which this case fits, as well as how some of these ongoing policy debates and constitutional debates may relate to this case. I think it is important to first off acknowledge that the facts of this case are heartbreaking. A young girl lost her life, and regardless of what the constitutional or policy issues are, that is something that needs to be acknowledged as a very sad fact. But we also have to take a step back and when we're examining the law and ask, what does this mean outside of that context? What does this mean more broadly for the future of innovation, not only for social media platforms, but for a wide array of user-generated content and online speech that often relies on algorithms? This case was also particularly interesting because it was one of the first cases to really try and interpret the NetChoice decisions. We saw that come up in the court's decision around whether or not algorithms were or were not covered by Section 230, or whether they should be considered the platform's own expressive content. So with those kind of key facts out of the way, I want to put a little more color on some of the underlying policy questions. One of the first things that comes up is that this case does involve TikTok. As James kind of alluded to, there is a very heated conversation around TikTok as a platform. It is still, however, important to note that that must be considered somewhat separately from the underlying facts of this case. The debate over the TikTok divest or ban bill is very separate from the debate over whether or not algorithms are First Amendment expressive activity or whether or not they are covered by Section 230. There are similar cases related to the algorithmic expression involving other social media companies, notably several challenges to Meta's Instagram platform, questioning whether or not it has an addictive nature, as well as on a recent case filed in Florida around the question of AI. One of the other elements in this case is doesn't matter if the platform was pushing specific content, in other words, choosing to engage on specific issues, to prioritize specific issues, or whether or not it was more passive. It was just kind of had a set algorithm, and this was all about the user interactions. That's been brought up in several of the debates around this case, but I think that goes to some of James's questions about why this may matter outside of TikTok. If we start to see platforms held liable for for their content moderation decisions using algorithms, that is going to impact the Reddits and X's of the world. That is going to impact the ability to do content moderation more generally. And we saw this come up when we saw the Google v. Gonzalez case last term, that many of these platforms were discussing how the increased liability, the perhaps inability to use algorithms and retain Section 230 protection could take away many of the tools they use when it comes to how they're able to serve the communities that they serve. That includes providing different options around content that users want to engage with. It includes providing positive opportunities for algorithmic discovery that can encourage users to find others that think like them, to engage in positive social media interactions as well. This includes not only social media platforms, but a variety of services that could be using algorithms with user-generated content. Think about some of your favorite review sites. If you interact with one type of book and you want it to recommend other types of books to you, or other similar restaurants based on restaurants you say you've visited in the past and left positive reviews for, they could lose Section 230 protection for those algorithmic recommendations. This is particularly critical as we potentially enter the conversation around AI. And I think when we're dealing with a case like this, that has such sad underlying facts, we often also have to remember that algorithms are about much more than just negative content. They're also about the ability of platforms to engage in providing positive content and providing ways for their users to take control over content they do or don't want to see by telling a platform that they vote something up or down, and that can have positive uses as well. Algorithms can help platforms provide parental controls to ensure that young users don't see certain types of content. Taking away Section 230 protection from algorithms has much farther reaching consequences than just having a potential impact on certain negative aspects as well. Then we have to discuss this kind of interaction between the First Amendment and Section 230. I think this has been a key point of contention that's grown in the last few years since we've seen this kind of renewed legal attention around these two issues. While there are Section 230 issues that often arise, there's also a separate question of platform speech rights when the platform is the speaker. And that's going to be one of the ongoing debates that we continue to see arising, but I think it's important that we recognize that there are clear user speakers in this case as well. When we're talking about the content of the underlying videos, that is a user's speech. We're talking about the user's speech in those cases, and these are the kind of scenarios that Section 230 was designed to have. There's nothing in Section 230 that prevents going after the user who created the underlying harmful content. And when we're considering the potential First Amendment implications of this, we also have to consider what this could mean for hosting content that is positive as well, but might be controversial. So with that, I will follow the norms set so far and yield the remainder of my time and pass it over to Ashley.
So this is what economists tell us, and people who study society are as path dependence. How initial conditions can change the course of things, sometimes in a benign way. So Jennifer, I much appreciate your concise remarks. Ashley, on to you.
Thanks, and thank you to the Federalist Society for having me. I'm going to answer a discrete constitutional question, which is whether the First Amendment shields TikTok for negligently giving to a 10-year-old girl the means by which she killed herself. And the answer is an emphatic no. And there are two ways to approach that. The first is to look at the actual Constitution and the original public meaning, and the second is to look at modern doctrine. So for those of you who are just practitioners, you can ignore this first set of remarks because we're going to suspend Cooper versus Aaron and just look at what the Constitution actually says. And it's really easy under the original meaning of the Constitution. Of course, TikTok isn't shielded from liability. First, because there is no incorporation of the First Amendment against the states. Obviously, the First Amendment speaks about Congress making no law. None of the other Bill of Rights speak in those terms. So the Second Amendment talks about the right of the people to keep and bear arms. The Fourth Amendment, the right of the people to be secure in their persons, papers, houses, and effects. The Fifth Amendment is talking about no person being compelled. The Sixth Amendment talks about the accused. You can go on and on. The First Amendment is unique in being a limitation of the Article 1, Section 8 powers that Congress can wield. No thinking originalist believes that the Due Process Clause incorporates anything, but if you think that the Privileges and Immunities Clause is more than an ink blot, as some originalists surely do, I think the First Amendment is uniquely outside of the protections that the Privileges and Immunities Clause would incorporate against the states. If that doesn't do all of the work for you, I think any originalist has probably heard of Bob Bork, and I would commend to you his seminal article from 1971 titled Neutral Principles and Some First Amendment Problems. He does a very cogent job excoriating the modern First Amendment doctrine, which was derived from Justice Brandeis, which has all of this flowery rhetoric about what the First Amendment and the freedom of speech is all about. He says that the framers believed that liberty was the secret to happiness and courage was the secret of liberty, and that fear breeds repression, repression breeds hate, and that hate menaces stable government, that the path to safety lies in the opportunity to discuss freely supposed grievances and proposed remedies. It sounds like the mystic aphorism of the fortune cookie applied to the freedom of speech as opposed to the Due Process Clause. And what Judge Bork then said was that the real freedom of speech that's protected by the First Amendment, if you want to proceed in a principled fashion, is just political speech, core political speech, because that's necessary in order to have a free, lowercase r, Republican form of government. I don't think you need to go that narrowly to say that a First Amendment that was enacted by framers who also believed in libel laws and slander laws and laws that prohibited lascivious speech would also be the type of First Amendment that says you can't give this sort of dangerous content to a 10-year-old girl, that's not something that falls within the protection of the freedom of speech as originally understood in 1789. And then if it's incorporated, if you believe in incorporation of the First Amendment as incorporated against the states in 1868. All right, so first principles to one side. I got to clear my throat to the Federalist Society crowd here. Now let's go back to Cooper versus Aaron and doctrine and say that we have to just follow whatever the Supreme Court says. This case is super easy under Supreme Court precedent as well, because regardless of what you think of Citizens United and whether corporations are entitled to the protections of the First Amendment as originally understood, there is black letter law from 2020, Agency for International Development, that says that foreign corporations and foreign persons are not entitled to First Amendment protections. TikTok is an instrument of the Chinese Communist Party. That's pretty far from being American. And as James alluded to, in February, it might be illegal for all of us to use it if they don't change their ownership structure. So open and shut under existing doctrine, the First Amendment says TikTok is not shielded from liability here. Even if you wanted to pretend that that binding precedent doesn't apply, I think here we would say that TikTok is not engaged in speech. So Hurley defines what counts as speech that's protected by the First Amendment. Of course, it goes beyond the literal word speech because that's how the Supreme Court has operated in this realm. It talks about things that are designed to convey a particular message that are likely to be received as such by at least some recipients of that message. Here, TikTok put through an algorithm into the For You feed of this 10-year-old girl extremely dangerous content. I don't think it was intending to convey any message. No human being was intending to convey any message to that 10-year-old girl. The algorithm was just operating in a way that TikTok believed would maximize its revenue and keep users using the product and the service for as long as possible. Now, you might say, isn't this fighting what the Supreme Court just said in NetChoice? Because the Fifth Circuit opinion from Judge Oldham said there was no speech that was involved there. And even though it was a 9-0 vacatur that sent the cases back to the 11th and the Fifth Circuit, the court majority does seem to say that there are speech concerns at issue when these platforms are choosing how to curate their content. I don't think I'm fighting NetChoice at all because the contexts are completely different. We all know that Silicon Valley is run by pinkos who hate conservatives. And so when they come up with their rules for moderating content, I actually think it is completely believable when they were keeping people who had views that were different from Anthony Fauci's from espousing their opinions about vaccines, when they were keeping people from suggesting that the COVID virus came from a Chinese lab in Wuhan, when they were keeping people from talking about Russia and disinformation and all of those things, that they were actually expressing their leftist views. They really didn't want those kinds of messages associated with their platforms. And under existing precedent, I don't think it was crazy for the Supreme Court to say that's expressive, that's speech, that gets First Amendment protection. Does anybody seriously want to argue that TikTok was expressing a message saying it's a good idea for you, 10-year-old girl, to go check out this blackout challenge? Of course not. The algorithm was not expressing any of the views of management. It wasn't expressing a political valence one way or another. It's not leftist speech or right-leaning speech or anything like that. It's not like the content moderation rules that Facebook and X and other platforms had that were at issue in NetChoice. What it was an algorithm that was designed to maximize revenue. It would be no different than an algorithm that said, let's leave a loaded 10-year-old gun near a school. It's not that that was being done to express a message or a viewpoint. It was being done by a computer program without any human input whatsoever to express a message of any kind. So under Hurley, I don't think that that gets any of the protections of the First Amendment under existing doctrine. Now, you might say, well, that runs you headlong into Section 230, because if they're not themselves doing the speaking, it must be the speech of others that they're being held liable for. But that's not true. They're being held liable for their negligent conduct in designing an algorithm and then not modifying it once they became aware that this dangerous content was being peddled to 10-year-olds. So that's what they're being held accountable for under Pennsylvania law. The final point I would say under existing doctrine, if you don't agree with me on that, and you do think that this is expressive conduct that falls within the ambit of the First Amendment, is I think it would satisfy strict scrutiny for Pennsylvania to say, you know what? Kids are different. They're impressionable. 10-year-old girls are going through all sorts of things that make it dangerous to expose them to this content. It is necessary in support of a compelling state interest to protect children, not to peddle this kind of thing to them. And TikTok can be held accountable if Pennsylvania negligence law wants to hold them accountable for it. Hopefully, I followed in the tradition of not using all of my time.
Excellent. Thank you very much to everybody for their remarks. I'm seeing there are already quite a few questions in the Q&A, and we will have ample time now to get to them. I wanted to start by asking a few questions. One, if I can ask James this in particular. So Section 230 in the relevant provision says that no provider of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Now, I think what you said, is, if I understand correctly, is that if Twitter simply, let's say, provides material to those people who seek it out, like somebody subscribes to my feed and it just gives me in reverse chronological order all of the things from my feed, then it's immune, because holding it liable for my tweets would render it a publisher. But if it recommends things through some algorithm other than reverse chronological order, then it's not immune. But I wonder how that can be reconciled with the notion of not being treated as a publisher. After all, one of the things that publishers do is select which of the materials that are available to them are going to be distributed to people, or going to be prioritized to people. In fact, historically, that is what publishers have done, much more than just publish absolutely everything in reverse chronological order, because historically, technologically, you couldn't do that. So if Now, I appreciate that the framing of these arguments on plaintiff's part is that we're trying to hold TikTok, let's say, liable for its algorithm and not for the material. But what you're really holding it liable for is for the algorithms distributing the material to users. That sounds like you're holding it liable for the algorithmic choices at whatever level about what to publish and whom to publish it to. Why isn't that a classic example of holding a provider of an interactive computer service, of treating it as a publisher by holding it liable for the algorithmic choices about what to publish?
Yeah, so I think it's important, as always, to just read what the statute says and apply it as it's written. So what it's saying is, and I'll read it again, no provider of an interactive computer service shall be treated as the publisher of any information provided by another provider or a third party. And so I'm not saying that because of the algorithm, we should act as though TikTok created the choke yourself until you pass out video. I'm not saying that you can hold them directly liable for the content of the video. What I'm saying is there are two things here. There's the video, which they cannot be liable for, and then there's their technological program that pushes videos that promote this kind of behavior on children. Obviously, there's a linkage between them, but the pushing and the sort of bombarding kids with videos about choking yourself until you pass out is distinct from the speech inside the video. I mean, one way to think about it that I just thought of, so maybe there's problems with this because you don't normally float a hypothetical for the first time at oral argument. But one thing you could imagine is, let's say somebody prints a bunch of pamphlets about how to shoot up a school, okay? And I didn't print it, I just found them all. And I go drop them off at the elementary school down my house, down the street from my house. No one would say that I'm the publisher of all these pamphlets or the speaker of all these pamphlets about how to, I don't think you would say that. I think you would say, I've done something separate. I have provided these things to the kids at the school, and I am liable for the provision, not liable for the printing, because I didn't create them. I don't know, maybe that doesn't work. But I think the point I'm trying to make is that when you make a decision that is distinct from the publication, that is something else. That is something more than mere publication. And that is what I think the complaint in this case is all about, and why there's not Section 230, a Section 230 protection.
So
you're making a skeptical face.
Am I right that you're distinguishing here publication in the sense of printing from distribution, which you would not view as
what I'm distinguishing
is
no, what the statute is talking about is the publication of the information. It's not talking about creating some program to get particular bits of information to particular people in a specific fashion. And all the statute says is that just because it's on the website, you're not the publisher of it. That's all it says. And you're trying to, I think in the question implicitly is trying to expand the meaning of publisher into literally everything that happens on the website. So, if I go to the 10-year-old girls and let's say a person designs it this way and says, well, all we're going to do is send 10-year-old girls anorexia videos all day long. I think that decision is a distinct thing from what the statute is talking about, because that is a decision beyond publication. Publication is putting it on the platform. That is a decision to specifically target specific people with particular content. And that is just not what the statute says. It just says you don't treat them as the publisher. It doesn't say they can do whatever they want just because they happen to be the publisher.
Jennifer had a reaction to that.
Yeah, please.
So a couple of things. To James's last point, I think this actually is a good time to bring in some prior Section 230 case law, particularly involving the roommates.com case, as well as the questions related to backpage.com, to understand how the courts have previously understood some of the contours of how do we identify a platform speech versus a third-party speaker when it comes to sometimes what may to an outsider appear to be difficult questions. In the roommates.com case, for example, part of the reason that Section 230 protection did not apply there was because the platform was proactively helping, through the use of its drop-down menus, users to avoid fair housing law, or was creating a situation where it could potentially do that. And thus the court said Section 230 didn't apply because it was proactively engaged in that. Many of the concerns around Backpage, which I will point out, was actually taken down by other government laws prior to the Section 230 carve out for sex trafficking online, had to do with concerns that the creators of Backpage were actively working with users to help them craft their comments in such a way to avoid kind of existing trigger words. I would also like to just mention this, and because it's something that I do think, given that the question of young people online has come up in this broader conversation, yes, the user in question was 10, but according to the terms of services of all of these platforms, including TikTok itself, you're supposed to be 13 or older in order to be engaging on these platforms. So this actually could potentially raise another set of questions, but since it's been brought up many times and I feel like very emphasized that this was a 10-year-old girl, there is a question of why or how is a 10-year-old on this platform to begin with? Did her parents know that she was on this platform? Had she proactively lied to the company about how old she was so that the company was not aware or reasonably aware that this was a 10-year-old user? So I think, while of course that is a heartbreaking fact that such a young girl died, given that the broader question of young people online has come up, or the content that young people are being served, I think it is relevant to point out that a 10-year-old user is something that should not have occurred under the platform's own terms of service.
I'm happy
So
to
if I could ask-
stipulate it's a 13-year-old girl. Sorry,
Pardon?
Eugene, go ahead.
I'm
I was just saying,
sorry?
I'm happy to stipulate for the discussion that they're sending the choking videos to 13-year-old girls instead of 10-year-old girls.
And these platforms are saying it's unconstitutional to make them have to verify the age of the people who are coming to their site. So I think it's a little rich to try and rely on mom and dad when, if the state tries to put in protections to protect kids, the platforms are again running to the First Amendment.
Just for the benefit of the audience, that is a reference to the Free Speech Coalition, I think, versus Paxton, a case that is now pending before the Supreme Court, which asks whether a state could mandate age verification. Therefore, for a screening there as the display of pornographic material, but in principle, the rationale the rationale of the challenge to that Texas law would apply to any kind of mandatory screening. Let me ask a question of Chris and Jennifer. And I appreciate that this is going beyond the current text of Section 230, but I take it at least some people in the audience are interested in what the right legal rule ought to be, not just what the right interpretation of the statute ought to be, especially given the Republican trifecta might provide somewhat more opportunity for statutory amendments to Section 230. I'm not sure how likely they will be. I don't know exactly how how it will play out among the parties, but at least it's on the table to revise Section 230. So I guess this is the question that, especially when children in the audience are involved, the law often puts mandates on various entities to try to prevent foreseeable misuses of their product. If in case of children, it's even, the attractive nuisance doctrine tells us that sometimes, even when the children really, really want to do something harmful to your property, you still have to try to take reasonable steps, not all steps, but reasonable steps to prevent that. Now, to be sure, the First Amendment does indeed, in some measure, limit various kinds of liability, including probably negligence liability. It's an interesting question, just when First Amendment limits negligence liability, often, I think. But at least in some of these situations, the claim is that the platforms not just should be aware of a certain risk, but are actually aware of certain risks that are manifesting themselves on the platform, and are in a position where they could, given that knowledge, take measures that would reduce the magnitude of that risk. So not exactly an actual malice, which is to say knowledge or recklessness standard, but perhaps not that far off it. And we also know that in some areas, like private figure libel, negligence is enough to impose liability under the First Amendment, but not Section 230. So Section 230 provides this really extraordinarily categorical immunity to social media platforms and other online sites. So why does it make sense to maintain such categorical immunity as opposed to providing maybe for some notice and takedown provisions or other things that might sound in knowledge or recklessness, or maybe even some sort of negligence or gross negligence standard?
Sure. So just to jump in quickly here, I think Section 230 strikes the right balance. I don't think it's surprising that I feel this way because, if you support free speech and you want to see a lot of it online, then it makes sense to have a liability regime that says the content creator is responsible for his or her own creation, not the website or interactive computer service, to use terminology from the statute, for providing it. And in fact, I just wanted to cite the text, since James has been referencing it. Congress defined interactive computer service as including websites that use tools that pick, choose, filter, screen, forward, search, or create subsets, organize, or reorganize content. So that sounds a lot like using algorithms that have been programmed with the expressive values of the website to display a ton of third-party speech. And I do want to bring in Jennifer's point that there is no denying that what happened is tragic. A 10-year-old is no longer alive because of this awful video that she saw. And there's no denying that. But what the liability regime under Section 230 says is that the creator of that video should be held responsible. And that is the right rule if we want to have free speech at scale online. And I think, in terms of like the Republican trifecta, a very interesting development has occurred over the last few months where I think a lot of Republicans have come to see Section 230 as enabling free speech online. Elon Musk, in an interview with Joe Rogan, said that without Section 230, X would be non-existent. It would not be able to survive the amount of lawsuits that plaintiffs would file for reasons that we might agree with, but also for political reasons. And this has popped up time and again with Section 230 case law, where a lot of plaintiffs will, try to use the law to suppress speech that they don't like or to punish speech that they don't like. And what Section 230 says is you might be right that the speech is problematic and that there is a cause of action attached to it, but that cause of action is to the speech creator, not the third party. And Section 230 it is not in any type of opposition to the First Amendment. In fact, it reinforces First Amendment protections that have existed for the last 200 years, but more or less have only been interpreted by the Supreme Court over the last 100 years. And ultimately, what is the right rule? Well, I think it depends on what we hope the internet to be. If we want to have a ton of speech online, and if we want to encourage websites to have different moderation regimes so that you can sort of pick and choose your content moderation journey, then Section 230 makes a lot of sense. But if we want a sanitized internet where user-generated content is pre-screened and reviewed, then that's a whole different, conversation. And I don't think that anyone here would support it. Ashley made the point about conservatives not having, access to the same opportunities to share their speech online as liberals do, but that's not really backed up by empirical evidence. In fact, there is a ton to show that conservatives do very well on social media. In fact, there's an article in the Washington Post, Wall Street Journal, and the New York Times, all saying that one of the reasons why the Democrats lost as massively as they have at every level was because they did not know how to leverage social media, that they did not know how to use today's technology to reach voters. And so I think, ultimately what it comes down to is, do we want to see an internet where users can share content, engage in content, and also have, websites that are moderating based on their own values? TikTok's terms of service show that they take very seriously harmful content. But when you have billions of pieces of content, certain things are going to slip through. And Congress recognized that when it passed Section 230. It did not say that you have to have perfect moderation in order to receive Section 230 protection. Instead, it said, we prefer that you moderate because we do want to have family-friendly websites, but we also want you to host third-party speech so that the internet can flourish as a marketplace of ideas. So, from my perspective, I think Section 230 gets it right. A notice and takedown regime would also just create a heckler's veto. And we would see the same type of situation where, tons of people would submit complaints about speech that is allegedly harmful. And then we would see an over censorship of online speech, right? Like, corporations don't want to be sued. And when they are sued, they want to settle. And, when all of that sort of happens, you create this dynamic where you see less speech online because it is simply the safer option. And that's why Congress passed Section 230 to begin with.
But Chris, so I appreciate these points, but and I appreciate the value of having more speech. But American law has almost never taken the view that the only value is more speech. For example, the premise of libel law, including libel law that does hold, say, newspapers liable for material that they publish, is we want more speech, but we also want some protection of reputation. The premise of copyright law is we want more speech, and one of the ways we actually get more speech is by restricting certain kinds of speech that copy other people's works. So with regard to federal intellectual property law, we do have a notice takedown regime. It's not perfect by any means, but it's not that, oh, well, Twitter can't function because of copyright notice and takedown. Facebook can't function because of copyright notice and takedown. They do. It may be, again, it costs them money. It may be that there's some degree of overchilling. I appreciate that. But that is a balance that Congress deliberately struck with regard to intellectual property. And, the skies at least haven't fallen. So even setting aside, for example, defamation, maybe you'd say you don't want to have that regime with regard to defamation. But for example, with regard to material that is being distributed to minors and that we have reason to think is going to be likely to cause physical harm to minors, why shouldn't the regime be more like the notice and takedown regime we have for copyright and trademark law? Rather than basically absolute immunity for the intermediaries, and you have to go at the original posters who may be overseas or may be anonymous and are basically not available.
That's a great question. I mean, to really sort of look at the statute itself of Section 230, Congress did make a decision not to
right. I appreciate that, but the question is, so Congress is now thinking about maybe revisiting that decision. So it made two decisions. It made one decision provide absolute immunity as to libel, as to material that may be harmful to minors, and so on and so forth, and then made another decision to provide notice and takedown liability when it comes to protecting the rights of intellectual property holders. Now, maybe the answer is it should have applied Section 230 to absolutely everything. But in light of the fact that Congress has made different decisions in different contexts, and that it is perhaps open to changing the decision, what about maybe moving the decision a little bit with regard to, again, certain kind of material, such as material that may lead some minors into killing themselves?
Sure. So, I mean, again, Section 230 is not absolute. So when you look at like the intellectual property carve out, that falls under a different federal statute, the DCMA. And what that statute has is a safe harbor, where if you are made aware that you have copyrighted material on your website and the copyright holder is unhappy that you have it, they can notify you and you have a certain amount of time to take it down and you won't face liability. So if Congress, wanted to sort of expand that regime, I suppose it could. But one of the important differences here is that intellectual property law is a congressional power, right? And so Congress has the power to sort of define it. And there is that safe harbor provision. But then when you start to look at tort law, especially state-based tort law, and all of the different regimes that have popped up, whether it's common law-based, statute-based, what have you, you can't really have a regime that says, this content is harmful, therefore we are going to flag it and, you must remove it. because if we have that, then we're just gutting Section 230, right? Because states have, they have similar enough tort laws, but they are different and they are expansive. And the Supreme Court, time and again, has refused to allow state tort law claims to infringe on First Amendment rights. And we saw this most recently in the Supreme Court's decision of Counterman versus Colorado, where even when it comes to true threats, which are not constitutionally protected, the court said there has to be a heightened mens rea requirement, right? There has to be a subjective intent.
But that's a recklessness
to
requirement.
harm.
That's not categorical immunity, right? It didn't say in order to maximize speech, we're going to make to strip away true threats liability altogether. And even republishers, if I republish a true threat, knowing that it's a true threat, and I have the relevant mental state, then in that case, I would be liable. So I'm not sure how Counterman helps.
Right. Well, if a website were to create speech that included a true threat or other forms of unlawful content, it would be held liable for it, or it could be held liable for it. And I think that is a fundamental difference here, right? What Section 230 recognizes is that when you create the speech, you are going to be held accountable for the consequences of that speech. But because we would like to have a lot of user-generated content online, we are not going to hold the website liable because tools like algorithms are necessary for organizing billions of pieces of content and for creating a personalized journey for users so that they're finding content that might be relevant. Now, of course, that also means that some harmful content will make its way through, right? Technology is not perfect, but over the last 30 years, it has improved dramatically. So to your point, I suppose Congress could create a notice and takedown regime for other forms of speech. But again, that leads us back to the policy question of what type of online environment do we want to have? And I think Section 230 gets it right. We would like to have a lot of free speech online, but we also would like there to be moderation.
All right. So thank you very much. There are a lot of questions, and I think the other panelists who have spoken a little less in kind of this follow-up will have ample opportunity to respond to those. And in fact, I will give Ashley and Jennifer first crack at those if you're so inclined. Let me try to pick and choose among the questions. So far, there are 28 in the Q&A, so an embarrassment of riches. So one question is, it's where does it say that the First Amendment and all other rights extend to children below 18 years old? And of course, we know that some rights don't. Other rights do, actually. You can't try a child, at least as an adult, without criminal procedure protections, but also child doesn't have Second Amendment rights. That's pretty clear, nor the right to sexual autonomy, nor the right to marry. Stepping back, of course, this is a Section 230 question, but there's been talk about the First Amendment. What about providing somewhat less protection for speech that is received by children, and that my understanding is with modern algorithms, platforms have a very good sense of what the likely age is of the recipient. Maybe not a 100%, but pretty good, especially if they're given some grace amount of time, like 18 plus or minus 1. But they have a pretty good sense of who is pretty certainly under 18. So what about that? And there are precedents on this point that I'm happy to leave to others to discuss, but that, I take it, is the question that the questioner is posing.
So,
Jennifer, you want to?
I want to jump in here if that's okay.
Please.
The courts have not fully established the scope of minors' First Amendment rights, but we can ascertain, particularly based on previous jurisprudence, for example, in the school First Amendment right cases, that they do have some degree of First Amendment rights. Of course, the famous line from the Tinker case of students and teachers do not abandon their rights at the schoolhouse doors. I think we can presume that may also mean they don't completely abandon their rights at the computer keyboard or the dial-up modem as well, but we don't fully know the contours of those rights either. Similarly, if we look at something like the Mahanoy case more recently, which involved the social media platform Snapchat and a profanity-laced rant of a teenage girl following cheerleading and softball tryouts that the school then tried to punish her for her behavior. The court found that that was actually the parents' decision with regard to First Amendment or to speech activity that occurred outside of the school context. So there's still some need for further decisions around this. This does also, though, relate to the broader debate, not necessarily in this case, but around age verification more generally, about not only the potential impact on some degree of First Amendment and expressive rights young people themselves may have, but also how in many of these cases, we're looking at the potential impact on adults who we do know have well-established First Amendment rights in the context of online speech, including rights to speak anonymously, including rights to access certain types of information. And because in most cases with the way laws operate, the only way to verify that someone is not under the age of 14, 16, 18, pick your age limit here, is to verify that everyone is over that age as well. So we see that oftentimes things that may claim to only be applying to young people's rights also apply to adults' rights. I'm sure someone will likely bring up the library filter case as the alternative to this point of view. But in that, one of the critical elements was that it could be removed for adults upon a reasonable request. So some of the question here also depends on when we are accepting the default and when we are accepting that default more generally, how many barriers there are to engaging in the expressive activity. We are seeing this, you mentioned earlier, Professor Volokh, the Speech Coalition.
First names, please. I'm calling you Jennifer. You should call me Eugene.
I'm sorry. Is the old habits die hard? You were never my professor, but I having referred to your book as Professor Volokh's book for years, Old Habits Die Hard. You alluded to the Free Speech Coalition v. Paxton case, which considers this question within a adult content setting or obscenities, broader than obscenity, but kind of in those leaning setting. But there are other cases. NetChoice v. Bonta immediately comes to mind that involve things like age-appropriate design codes, and we've seen several states try and pass age verification laws, all of which, and Chris can correct me if I'm wrong, I believe are currently enjoined under First Amendment grounds as they relate to adult speech rights in the courts.
Just one thing about age verification: the Fifth Circuit upheld the age verification requirements. Other courts struck them down, and that's now before the court. Or am I misunderstanding the point?
Just super quickly to clarify, so the lawsuits that NetChoice has brought are focused solely on websites that do not have adult pornographic content on them.
I see. You're focusing on that.
Right?
Yeah.
So yes, I think that's an important clarification.
Different breakup.
The Fifth Circuit case in Free Speech Coalition v. Paxton deals specifically with age verification for adult pornographic content. There are broader cases involving age verification and age-appropriate design codes that apply to online platforms more generally, that NetChoice has been the lead plaintiff in several of those cases with regards to their potential impact, not only on the speech rights of young people, particularly older teenagers, but also on the speech rights of adults that may lose rights towards anonymity or towards other access to.
So I appreciate that, although those arguments were rejected by the Fifth Circuit as to the porn age verification, but one can certainly imagine different analyses depending on what the age verification is trying to screen out. Ashley, I wanted to hear your thoughts on the First Amendment issue, and I wanted to throw in a case which I thought would get mentioned, which is Brown v. Entertainment Merchants, where the Supreme Court struck down a law that restricted, relatively mildly restricted, children's access to violent video games. And children could still access them, it's just basically they need to have their parents get them for them. And the Supreme Court said, no, whatever lower protection there is for speech by and to children that's limited to pornography, because there's this historical exception, doesn't apply even to violent video games. So Ashley, what would be your thoughts about the prospect of lower First Amendment protection for children's access to certain material in light of Brown v. Entertainment Merchants?
Yeah, I don't know why you're surprised I didn't bring that up. It's not good for my case, and I'm
Oh,
already...
no. I'm surprised Jennifer didn't bring it up.
Yeah. So I guess I would say a couple of things in response to that, in response to Jennifer. The first thing I'd say is respectfully to Jennifer and many others who succumb to this fallacy of judicial supremacy, unshackle your mind. You don't have to say we don't know the answer just because the Supreme Court hasn't told us so yet. We have a First Amendment. We have a nation with a rich history and tradition. We don't need the 9 justices to announce the rule, and until then, we're just sort of stumbling around in the fog. We have the tools of interpretation ourselves that they're supposedly using, and we have a long historical tradition of protecting children in our society. It goes back all the way to the beginning, before we even were a republic, to the colonies, to merry old England. And so this idea that we just have to wait around until they disambiguate the doctrine is not correct. So, try and think a little bit broader about what the First Amendment actually does based on our nation's history and traditions, and I think it'll get us to the right answer. But the other thing is, I want to come back to a point that Chris was making, because I think I was trying to be charitable to these platforms and say sometimes their algorithms actually are engaged in expressive activities of the platforms themselves, and sometimes not. So I'm not someone saying just because it's code, that means it's not speech. If someone writes into a program, we want to keep conservative speech off of our platform. We want to keep speech that doesn't support Anthony Fauci off of our platform, and the geniuses go into their room and come up with that code and apply it on their website. I think that can be speech. I don't think everything that the algorithm does is necessarily expressive. If you just say in a content neutral way, find the things that this particular user clicks on most and look for things that are like that, irrespective of what it might be about. We don't care as the programmers. We don't care as the platform. We're just trying to maximize revenue. We're not expressing anything. That's like the prune yard case. That's like the mall owner who doesn't really care about what is on the leaflet that is being distributed outside of the stores, where the court then says, yeah, the mall owner is not engaging in his own curation of content. He has to let the leafleters leaflet. I think I might have heard Chris saying, no, even here in the awful facts of this case, and everybody acknowledges it's terrible what happened here, even in the awful facts of this case, the algorithm was engaged in expressive activity. I kind of double dog dare TikTok to say that. I dare them to say in court on remand, yup, we were engaged in speech. It was our speech promoting to a 10-year-old that she should do something that could cause her to kill herself. I'm extremely excited for them to make that argument if they have the audacity to make it.
So let me turn to another question.
Gene, do you mind if I just make one?
Yep, James,
Sorry,
by all means, please.
Yeah, there was just one textual point. I know it's very easy, I think, to get into the abstract sort of policy stuff. I just want to make one small textual argument about the statute in response to something Chris said about 10 minutes ago before we move on to the next question. So Chris brought up the definition of access software provider. I really hope people go read the statute. All that is talking about the platforms that go within the statute. It's not talking about all the things that they have immunity to do. It's just saying that platforms with these functionalities are then in subpart C. And then at that point, it tells us they're not a publisher because they host other people's speech, and they're not a publisher even if they content moderate. It does not say that everything that makes them an access software provider is immune. I mean, I am just a lawyer. I am just trying to read the statute. This is not Athens, and we're not doing direct democracy here. And the only other point I wanted to make is there's a lot of policy arguments being made here. All I would suggest is, if we think new rules are needed and reading the statute the way it's written doesn't work, who is best situated to obtain new rules? The parents of dead 13-year-old girls who are just people out in the country, or the most powerful, well-connected, well-funded, influential companies in the entire world? So I guess I would just suggest, if we're worried about error cost in the wrong interpretation, interpret Putting liability shield a little too narrowly is actually much easier as a functional matter to fix than interpreting it too broadly. I appreciate Eugene for letting me have a second there. Thank you.
And sorry, Eugene, but if I can jump in.
I'm sorry. Can we just turn to the next question? And I'm sure that whatever anybody else wants to say can be woven in to the future question. But I wanted to keep the pacing going a little bit more with the questions. So here's a question from Charles Carrion. If we're going to lean on the ability to sue the original content creator, how do we deal with user anonymity, foreign defendants, shell publishers, and other hurdles to pursuing those claims? So this, Jennifer, not your opportunity to respond, and then tie things together as you like.
I think this is a very complicated question, because I do agree with Chris that the underlying nature of Section 230 is this idea that you sue the person who said it, not the fact that a platform existed that they were allowed to say it, to in some ways use James's analogy earlier that I know he was just trying out. I don't think any of us would want to say we can't have print shops because someone could do something bad with a print shop, and we're going to hold the print shops liable for whatever anyone ever uses them for. We would say, no, if you print something bad at a print shop, you're liable for printing something bad at a print shop. I think,
but Jennifer, if I may interrupt, print shops are potentially liable if they are aware that what they are doing substantially promotes illegal conduct, whether sometimes for defamation, but also other things. They're not liable on a negligence basis, or certainly on a strict liability basis, but they don't have categorical immunity.
And there are notable exceptions to Section 230, including federal criminal activity. And so I think that I don't think James's analogy works perfectly, but I was trying to pull on the prior analogy there. And in part, this does actually set me up to answer some of the comment I wanted to make in response to his question, which is we also have to think about this outside of large platforms. Yes, TikTok in this case is a very large, popular platform, but when we're talking about the potential liability questions here, we're talking about a lot of small platforms as well. Farther down in the Q&A, someone brings up Truth Social, for example, which is a new popular platform, but is much smaller than, say, a TikTok compared. One can think of some of the alternatives to Twitter that have recently popped up when it comes to the ability to offer perhaps better alternatives, alternatives that see a problem with an existing algorithm that the parents of those 13-year-olds can go to and create, because they don't have to worry about being sued into oblivion for creating a new platform that was more beneficial. I do think, though, it is a very difficult question of what do you do when you cannot identify the user. And I think that's a very difficult question, because I think it gets into much more complicated First Amendment questions, particularly around questions of anonymity online. When, if at all, is there a requirement to unmask? Because we want to make sure, too, that, again, back to Ashley's point about kind of time-honored interpretations of the First Amendment, the ability to speak anonymously goes back to the founding of the US. We don't want to see that completely go away just because we now have the internet era. And so I think it is a very complicated and difficult question, and I'm sure Chris has further thoughts on it.
Well, so if I could just follow up briefly, just because I want to make sure that the reader's question, or the questioner's question is kind of given its due. If indeed there is the ability to speak anonymously online, or speak from foreign countries in a way that even if you're identified, there's really nothing that's going to be done about you, then the model of Section 230 isn't, oh, go after the original author. It's no liability for anybody, practically speaking, at all. It's as if the print shop wasn't just saying, look, go after the person who did the order, but the print shop says, we don't keep records. We have no idea who printed the order. It's impossible to know. So basically, if somebody is damaged by this, you can't sue the original author. You can't sue us. You're out of luck. Is that indeed a sound approach? Is it the approach that Section 230 ends up practically doing? Again, maybe it is what Section 230 does end up mandating in situations where you can't identify the author, but is that good?
Well, I think it all comes down to, looking again at the statute, what is a publisher, right? Section 230 does not define publisher, but we know from the common law and from, just the ordinary meaning of the word that it encompasses sort of the creation or the compiling of information for dissemination or distribution. And so publisher liability has subsets, sort of like conduit liability, as well as the broader distributor liability framework. And, the Anderson dissent / concurrence sort of tries to parse that out. But ultimately, what Section 230 is saying is that if you are involved in the dissemination of speech, then you are a publisher that would ordinarily might face consequences for your publishing decisions. But because of this law, we are going to say that you are only liable when you yourself create that content and then disseminate it. And so to your point, Eugene, I'm not entirely sure what the right perfect rule is here, but I think that this country has made the decision, both through the actual codification of the First Amendment and subsequent interpretations of it and applications to factual scenarios and evolving technologies, that we generally do not want to impose liability on folks for content. Now, there are, of course, certain categories of speech that are not protected by the First Amendment. But here, I don't think this has been brought up yet. As awful as this, blackout challenge video is, it is lawful speech. And that is a complicating factor here because, what liability regime would really exist even under the First Amendment that could apply? And I mean, to get to that result, to impose liability for, showing a video that others created that is lawful but awful, would mean sort of gutting decisions like Brown, which was written by the late, great Antonin Scalia. He says in the Brown decision that violent video games might be awful. In fact, they might have, very realistic simulations that are quite awful. But ultimately, violent video games are constitutionally protected for both adults and for minors. And so the proper outcome is for parents to make the decisions on behalf of their children, not the government. I personally think that is a correct interpretation of the First Amendment, but I recognize that I think Ashley would probably have Brown overruled, and that's also that could be something that the Supreme Court one day does. I hope it doesn't come to that, because then I think we would see a lot of laws that chill speech, not just on behalf of minors, but also adults. But of course, the Supreme Court can always revisit its decisions.
Well, so this actually brings up or ties together several questions from the Q&A that I thought I might kind of reformulate this way. So one issue that's come up here is, what's the proper First Amendment limitation on negligence liability for speech that allegedly causes physical harm? And a related question is, well, to what extent should the law be more sensitive to whether the audience is children or adults? And Brown suggests that there are very substantial limits, in fact, very, very serious limits. Brown was a 5-4 decision. It was an interesting coalition with basically 3 of the liberals, let's say loosely, and 2 of the conservatives, with Chief Justice Roberts, Justice Alito, Justice Breyer, and Justice Thomas either concurring in the judgment or dissenting, but basically disagreeing with the Scalia, Kennedy, I want to say Stevens, Souter, and Ginsburg. No, yes, I think that's right, position. But in any event, so let me ask you folks, if you want to tell us, stepping away from Section 230 as such, what you think is the optimal, constitutionally sound solution to these questions. So one possibility is to say there is very broad authority under the First Amendment for punishing speech that is negligent in the sense that it leads, the jury would conclude it unreasonably leads to physical harm. speech that encourages suicide, that encourages anorexia, that encourages reckless self-harming behavior, that encourages drug use, even when it's addressed to adults. Because after all, Section 230, at least right now, does not distinguish speech to adults from a speech to children, although maybe it should. So one possibility is basically we should apply negligence law to situations where there is physical harm that is caused, at least maybe set aside kind of caused through political advocacy, just caused through blackout challenges and the like, even if it's caused to 18-year-olds, 19-year-olds, 20-year-olds, 50-year-olds. A second possibility is to say the First Amendment does not allow negligence-based liability for this kind of speech. Set aside one-to-one speech that might be solicitation of crime, let's say, or something like that. But if you're talking generally, encouraging people to do things that may end up being really, really bad for them, and a jury is prepared to say you are unreasonable in doing that, there should be no liability, even if the prospective harm is to children who might see this encouragement and foolishly, children being often foolish, go along with it. And a third possibility might be, again, as a First Amendment matter fundamentally, well, the First Amendment protects speech that is addressed to adults, even when it negligently causes harm to at least those adults. But it doesn't protect speech that is addressed to children, or where the speaker is aware that a very large part of the audience, or perhaps a particular member of the audience, whom they could shut off communication to, is a child. And that situation, First Amendment doesn't protect that. So let me just ask what the panelists' view is. And let me start with Ashley.
Well, you heard my view about what to do based on the original meaning of the Constitution. I haven't heard anybody.
Let me, if I may interrupt, just because, many of the people in the audience are lawyers, or at least practically minded people who want to know kind of what realistically is a likely scenario.
Yeah.
So in a situation where the court might be willing to review one or another of its precedents, but isn't going to revisit the incorporation doctrine, let's say.
I'll take that as a concession that I'm right on first principles and then go to practicalities.
I take that as a joke.
So, yeah, I think that the doctrine certainly ought to be that children are in a special category. We've always treated children as in a different category for very good reason. They're children. They don't have the faculties necessary to process information in the same way. The whole marketplace of ideas and coming to political and other truths, everything that we sort of presuppose as infused into modern First Amendment doctrine doesn't apply certainly to 10-year-olds. And so, violent video game cases notwithstanding, we can cabin that to its facts. And in the modern era where there's all of this proliferation of information coming from these platforms, I think it would be a completely reasonable thing for the court to eventually get to this question and say, we're going to treat kids as special. I think that would be a salutary rule if we're all just going to be making it up, because obviously kids are being bombarded today with information that they didn't have at their fingertips with supercomputers in their pockets in the generation when I grew up. And protecting kids is perhaps the most important societal function. And so getting First Amendment doctrine from a modern doctrinal perspective correct, if we're not going to do first principles, is where I would come down.
Got it. Thank you very much. Jennifer.
So I would emphasize that while I certainly understand where Ashley's coming from, we're not just talking about kids in the sense of 10-year-olds. We're also talking about 13, 14, 15, 16, 17, 18-year-olds who would also be potentially impacted by these doctrinal changes that have different expressive rights and different needs and have been using platforms in very positive ways as well that often don't get told. But to go back to the underlying question, one of my concerns when we often hear these ideas of kind of additional carve-outs, or the idea that otherwise objectional is too broad, we need to narrow that down, and have more of these kind of, a sesta fosta for drug content, or for eating disorder content, or for suicide related content, all of which most of us would agree are very sad and horrible things, is what is it going to also take down in terms of the positive speech combating that same type of content. Because when we think about the tools available to platforms, and particularly when additional liability is put on, as is often the case with proposed changes, what we would see is that in most cases, there's going to be a much broader silencing, which means you don't only take down the pro-suicide content, you take down the here's how to get help if you're currently suicidal content. You don't only take down the pro-drug content, you take down very important conversations to patients dealing with legitimate pain management issues. You don't only take down the pro-anorexia content, you take down broader pro-health content, you take down pro-recovery content in the process, because in most cases, platforms are going to be more concerned about what happens and then what happens to those positive voices that are being silenced in the process. And when that darker content just goes darker on the dark web. Now, I would like to add one more element to this conversation, which I think is something that we would probably all be in broad agreement with, given that this is a Federalist Society question or a Federalist Society panel, which is if there are to be such changes around such type of content, that's a role for Congress. That's not something that should come down from a court in a form of quasi-legislation. And while I certainly have concerns about it being done with changes to Section 230, as I just expressed, the idea that, a certain type of content being ruled not covered by Section 230 that's otherwise lawful speech by the courts is concerning, is in some ways even more concerning to me for what that may mean for broader separation of powers conversations as well.
Great. James.
Yeah, so I think we've covered the statute. I agree with Jennifer. We should not rewrite the statute. I think the statute's actually pretty simple. I hope everyone goes and reads it and they can come to their own conclusion. It's not that hard. On the First Amendment, look, so, Eugene, I clerked for the same judge as you did on the Ninth Circuit. I love the First Amendment. He loved the First Amendment. I kind of came up in a very libertarian mindset where you want to have a broad understanding of free speech. So I actually am very, conflicted on this stuff. I mean, as I get older and I sort of learn more and I experience, the world more, and these platforms are very different from things I had when I was a kid. I have little girls, 11 and 8, and I worry about this stuff. I guess here's what I think, and this isn't super satisfying, but maybe it's helpful. I worry a lot about broad rules in a very complex ecosystem that we don't really understand. And that the judges don't really understand. The way these platforms interface with 10-year-olds is not the easiest thing to figure out, at least not for us lawyers on the phone. Maybe Chris understands it because it's his world. I don't pretend that I really understand it. And then I also worry a lot about what I would describe as facile analogies that don't really make any sense. So there's a very famous exchange. I used to do judicial selection at the White House, and we always ask people about this because I think it's so interesting to see how they react. So in the violent video games case, there's a very famous exchange and oral argument where Justice Scalia is asking some question about Hansel and Gretel and all these sort of very vivid novels that were around at the framing. And he says, don't you think those are protected by the First Amendment? And the lawyer's kind of fumbling around, and Justice Alito interjects and says, Justice Scalia wants to know what James Madison thought about violent video games. Which I thought was very funny and sort of a cutting remark. And I think the point Justice Alito was making is the idea that there was some kind of settled understanding at ratification or even at incorporation, or rather the Civil War amendments, about what to do with violent video games or algorithms or TikTok is really not reasonable. I mean, it's very hard to take the original understanding of these words and say all of these complex policy issues have been pre-termitted here in 2024. And so I think that is an argument for taking really, really small steps and being really, really careful. I love X. I spend way too much time on X. I don't have Truth Social. I bet it's wonderful. I bet it's the best app there is. But I probably should get it soon because it's becoming increasingly important. And I'm not sure how all the rules will work. So I guess my suggestion to the justices, if any of them are listening through an anonymous account, is I would deny certiorari if they seek it in this case. I would let the law continue to develop in the circuit courts. And I would just be really, really careful about what we do here because there could be lots of unintended consequences. Thank you.
Got it. Thank you very much. We're almost at the end of our hour and a half. Chris, you have the last word.
Oh, awesome. Okay, so I'll keep it super brief. I think underlying every single person's argument and all of the discussion today is a question of who decides what content is harmful and on what basis. And I think that sort of where we're at as a country reveals that there is not much agreement over what is harmful content. And that's also been true for most of US history. We are a country that disagrees with each other quite a lot. And so the idea that we can have some type of regime that says this content over here is uniformly considered harmful, and therefore we are going to limit its distribution to children or adults, what have you, I just don't see that working. And I also think that we have to sort of keep in mind that governments have a natural tendency to think that they are correct over what materials are proper for citizens to read or to engage with. And I don't know that, people in Texas would feel comfortable with, how California might approach that problem, or in California is not going to feel comfortable about Texas. So maybe that's an argument for, state-based regimes, but again, that would come at the cost of online speech. And so, I'll just end by saying that there might be that there is no perfect answer. There's no perfect response for what to do when there is content online that is harmful. And I do think that, what it comes down to is parents do need to be involved in their kids' lives, and most of them are, right? I am not trying to blame parents at all. I'm not trying to say that they need to do more. I am encouraging lawmakers, though, to consider what tools they can provide both students and their parents about online literacy, about how to keep themselves safe online, and what to do when they engage with certain types of content. I recognize that's not a satisfactory answer because it's really not going to address the very genuine concern all of us have about 10-year-olds viewing content that is harmful. But I do think that in our constitutional republic, it is the best response to date. And I do think it should remain that way because I personally just do not see a universe in which the government deciding what is and is not appropriate speech, even if it's just for minors, is not going to result in censorship.
Got it. Folks, thank you so much to all of you for your remarks. Very, very helpful and illuminating. Thank you to the audience for showing up and watching, and for the questions. I'm sorry I couldn't get through all of them, but there was an embarrassment of riches. Thank you to the Federalist Society for putting this together. And
thanks so much, everyone.
Great
seeing you.
Thanks. Oh, let me I have to say the things. So Professor Volokh, thank you very much. Panelists, same thing. On behalf of the Federalist Society, I want to thank everyone, including the audience, for participating in the event, joining like the day after NLC. It's a wonderful crowd, and I think speaks, and all the great questions, I think speaks to what an interesting question it is that we're dealing with. We welcome listener feedback by email at info@fedsoc.org. Thank you all for joining us. We're adjourned.